We have who we're going to have. It's about 5 minutes past our start time. What I'd like to do is just introduce myself. Obviously, Christopher Clark, the town administrator here in the community. Just one of the things in terms of, generally in my experience, a lot of people come and they ask me for advice in regards to the ethics laws and open meeting law. I certainly try to do my best to give people advice, to point them in the right direction. But I think it's better sometimes when we have the opportunity to have the professionals come in that deal with the issues on a more day-to-day basis. So we have scheduled, actually, I guess 3 events. This is the first event. They are voluntary, but we do request that you attend. Just everyone should improve their knowledge base. But we have 2 on the conflict of interest statutes, and then 1 on the open meeting law. The open meeting law is more encouraged for folks that have boards and committees. The boards and committee members should really be encouraged to attend that. And just so folks are aware that we are going to be filming this, so that we'll have it on the website so people will be able to see it at a later date. Not everyone's able to make Monday evenings. So if you do say anything, just be aware that, this will live in infamy on the web somewhere. With that being said, what I'd like to do is turn it over to Brian Riley, an attorney at Copeland & Page, who specializes in these 2 areas, and Brian will be the presenter at each of these forums. If I have that right?
Yeah. Yes.
Go ahead, Brian.
Okay, thanks very much. Thanks, Chris. Hello, everyone. Thanks for coming. We'll try to keep this short and relatively painless. And just so you know, I was asked to give this conflict of interest one twice this afternoon and next Monday. It will be the same thing, so if you're here today, don't come next week. You won't hear anything new. The conflict of interest law, like the public records law and the open meeting law, are, for people who serve in town positions, all 3 of these really can kind of be a pain in the neck to deal with. But they're kind of necessary evils. They all sort of make up the sunshine laws, where citizens want to be able to see what's going on in local government, kind of keep things out in the open, not have people who have private interests that conflict with their public duties, all that kind of thing. And so the conflict of interest law is there. It's been there for, I guess, about 40 years now, maybe almost 50. And it is good to kind of get a refresher now and then if you're in a town position, just on sort of things to look for, red flag kind of issues. And so I will try to go through those. Since we are filming, I guess if you have a question, and I think it works better if we take questions as we go rather than hold them to the end. I guess you can either stand up and talk at the microphone there, or I could try to repeat it just to make sure it gets in there. There were 3 handouts in the back I saw you getting. One is just a copy of these slides. And then there's a couple letters we sent out. One concerning some regulations that the State Ethics Commission enacted about 3 years ago, which filled in a lot of gaps. They were very useful that they enacted these. And then another one was a kind of a recurring issue under Section 19, which I'll mention. I won't go through the letters in detail, but they're there if you might use them. This is our kind of standard disclaimer, but it's actually very apt for the conflict law in particular, because the Chapter 268A is fairly complicated. Certain parts of it are difficult to read unless you've been reading it for years like I have. And they really turn on the facts of a specific situation. You might have 8 things which look like it's a problem, and all of a sudden there's the 9th one which qualifies you for an exemption. So I'm going to be talking sort of broad brush, but if you think you have an issue you want to find out about, you can certainly go through our office or the Ethics Commission. I'll mention this at the end again. The Ethics Commission has a legal division, and you can call in and ask for the attorney of the day and get something over the phone to help steer you the right direction too, and that is free. So the conflict of interest law is General Laws Chapter 268A. There's about 28 sections now. Several of them deal with state employees and county employees, to the extent counties are really around anymore. So not all the sections apply to municipal employees. And then the Ethics Commission has adopted some regulations at 930 CMR, and I'll talk briefly about those as well. But I'll start off actually with Section 3, but the ones that apply exclusively to municipal employees are Section 17, 18, 19, 20, and 23. And these are listed here. Acting as an agent, former employees, I won't really get into that unless somebody has a specific question, but if you serve in a town position and then you leave that position, there are certain things which will kind of haunt you for a while, prevent you from getting involved with on the private side. And then 19 and 20 and 23 are kind of the most common. So I will talk about those as we go. Section 1 has the definitions section, and the conflict law applies to all municipal employees as defined in the statute, and it's defined a lot broader than the typical what you would typically think about as an employee, which would be someone who's hired and they get paid to do something. This definition is a lot broader. It's a person performing any service for the town, holding any office, position, or employment, whether by election, appointment, contract of hire, or engagement, with or without compensation, full, regular, part-time, intermittent, consultant basis. So it's extremely broad. It covers everybody from a full-time paid employee to someone serving on the zoning board, for example, who gets nothing for that privilege. But they're also covered by the law. The only exclusions the statute gives are in towns that have representative town meeting. If you're an elected representative, that doesn't mean that alone doesn't subject you to the conflict law, or an elected charter commission. But other than that, it is very broad. As you can see, it can apply to contractors. For example, the planning board might hire a civil engineer in town to help them review plans for some project and give advice, and that may last for several months. While that engineer is serving in that capacity, he or she is a municipal employee, and they will have to watch out for other things that might trip them up. You may hear the term special municipal employee sometimes. This is it's defined as a position that first of all has been designated by the Board of Selectmen as a special employee. Basically, the only difference is that if you qualify to be a special employee and the selectman approves and votes to designate your office or board as specials, there's a couple of sections that have additional exemptions, make it a little easier for you to have perhaps an interest in a contract with the town. There are a couple of positions by statute that are designated as specials. I think Housing and Redevelopment Authority employees get that by statute. But in general, everybody else needs to request and be approved by the Board of Selectmen. And it applies to the position, not the individual. So if the selectmen vote to designate the Conservation Commission as special employees, it applies to all the members and all future members unless or until the Board of Selectmen votes to rescind that designation. To be eligible, the position has to either be unpaid or if it's a part-time position, you can get compensated up to 800 hours a year, which I think is roughly 15 hours a week. Those positions are also eligible and may ask the selectmen for that designation. It really varies from town to town. Some boards of selectmen have said they felt like they're giving special favors to certain positions and they don't like to do it. Other boards are more liberal with it. I will say that the Ethics Commission encourages boards of selectmen to make this designation just because it kind of creates more opportunity for people in the community to be able to serve without it running into their private employment, for example. A couple other definitions. Immediate family, section 19 deals with this one, which I will deal with. It's defined as the municipal employee, his or her spouse, and then each of their parents, children, brothers, and sisters. Now this can lead to a couple of odd kind of circumstances. because if I'm the municipal employee, my wife, of course, is also immediate family, and my wife's brother falls under this definition, my brother-in-law, and so he would be part of the immediate family as well. However, if I had a sister, my sister's husband, who's also my brother-in-law, falls outside of this definition. So, again, the definition has to be looked at carefully. If you have a cousin, that's not going to trigger the Section 19 problem, because that's outside the definition. And there are several sections which say a municipal employee can't do this or that, but they may avoid a violation by filing a written disclosure. And in general, these are all written statements about what the facts are, why this is being filed, and for the most part, appointed officials or employees file it with their appointing authority, and it's a public record. If elected officials who don't have an appointing authority file it with the town clerk. Okay, Section 3. Section 2 basically says do not accept bribes for any illegal purpose, illegal intent. So I'm sure I don't have to worry about that with this group. But Section 3 is a little more subtle, and it says a municipal employee cannot accept a gift of substantial value, which is defined as $50 or more, which is given for or because of an official act performed or to be performed under your official responsibility. And so, the bribe is obvious, but you may, let's say you're a building inspector and somebody had a big project and you gave them lots of advice and helped them get through, and then finally the thing is done, and the person is so grateful they want to give you a bottle of wine just to say thanks for helping me out. That may or may not be a problem. It depends how good the bottle of wine is. But that is, as innocent as that is, that gift was given because of acts that you performed in your official capacity. The Ethics Commission a few years ago, and this I won't go through in detail again, but one of my letters talks in a little more detail about these regulations. The Ethics Commission kind of cut some lines on what gifts are okay, what need a disclosure, and what you just can't accept. Gifts which do not fall under Section 3 are ones that are entirely unrelated to your office or any official action. Somebody's giving you a birthday present. They're not giving it to you because of your official office. Maybe people in your office are giving you something. A retirement gift kind of thing might be a little different, but the town employee phone discount plan, the Ethics Commission actually issued some opinions on that. A phone company might come in and say, we have this great group discount. We'd like to offer it to town employees. And originally, when the Ethics Commission first heard this isn't a new thing anymore, but they said, well, we're not sure about that because that means you're getting a benefit, a financial benefit, because of your official position. But they eventually relented. Sometimes they kind of have to get dragged kicking and screaming to this, but they finally decided that if this kind of discount plan, this financial benefit, is offered to all municipal employees equally, and it's the kind of thing that this company would also offer in the marketplace to private employers as well, that would be outside of Section 3 as well. If you win a raffle prize, also that's not that's because you're lucky, not because of your official position. So that's okay. Oops, didn't change. There we go. I gave that example about somebody wanting to give a bottle of wine to the building inspector. If the gift is less than $50, but it is related to their official position, in general, they can accept it, but they will need to file a written disclosure. Again, that would be with the appointing authority, or if you're an elected official, with the town clerk. It's just to kind of put on record that I'm the building inspector, so-and-so, because of, my interactions with him, gave me this gift. It's not to influence me in anything I have done or are going to do in the future, but it just kind of creates a public record. So if anybody, concerned they hear about this later, if the disclosure was filed, that covers the inspector from any potential violation. So these disclosures can be very important in that way. If it's a same fact pattern, but it's a $100 bottle of wine, almost without question, the employee is going to have to say no to that because it's of substantial value and these exemptions don't apply. The regulations then also put in specific exceptions. I won't go through them in detail, but one example is, let's say the town is looking to buy some expensive piece of machinery, and the nearest place that sells it is down in Philadelphia, and the company wants to, bring the DPW superintendent down to look at it, fly him down, put him up for a day. Obviously, that's going to be more than $50, but if it's serving a legitimate public purpose, the Ethics Commission says that won't be a violation. There are, again, written disclosure requirements and that kind of thing, but there are a few examples like that. Also, incidental hospitality, you're going to some conference and you're going to get a dinner out of it. Those kinds of events, rather than a particular person kind of whining and dining you for something which is going to come before your office. Those are also, for the most part, okay. They may or may not require a disclosure depending on the amount. Let's see this. The letter I have mentions a few others. One I'm going to mention in a little bit. Okay, I guess that's all the ones with gifts. So now jumping up to the sections that apply just to municipal employees. Section 17 says that a municipal employee may not, one, receive compensation from anyone other than the town, or act as an agent or attorney for anyone other than the town with regard to a matter in which the town is a party or has a direct and substantial interest. And so this is to avoid, a person wearing two hats. They've do something for the town, but then they want to come in and act as an agent for this private company, private individual who has some business in front of the town. That could at least lead to some divided loyalties, and so the conflict law says don't do it. Same if you're being paid by a private person for something in which the town has an interest. Again, that's prohibited. The Section 17 does treat special municipal employees a little different. This is one of the sections that does that. Special employees basically are prohibited from these two things, these two categories, only if it's something which is going to come before their office or their board. So if, let's say I'm an attorney and I'm on the school committee, if the school committee are not special employees, I'm not allowed to act as an attorney for someone in front of the ZBA, for example. Section 17 would prohibit that. If I'm in the school committee and they are special employees, I'm only prohibited from coming before the school committee and sitting on the other side of the table and acting as an agent. So that one's kind of obvious as well. But that one, special employees do have a little more benefit to that. Acting as an agent, it's not defined in the statute, but the Ethics Commission has kind of developed it over the years. Acting as an attorney is pretty obvious, a member of the bar representing a client. But acting as an agent can be a lot less formal than that. Basically, if you're representing another person or an organization in any kind of dealing with the town, you might be acting as an agent, and so you need to be careful with that. And it applies if you are, on behalf of this other party, if you are contacting or communicating with another town office on their behalf, you're acting as a liaison between the town or that party. You, show up before a town board, sitting with them to help them make their presentation. Let's say, again, you're a civil engineer and you're hired by somebody who has a development project. You can't come before the planning board and sit there and talk about this project because you're acting as an agent for the applicant. And even, mailing mailing documents on behalf of someone to a town office might do it. And it even goes down to, certainly if it's a corporation or a nonprofit or something, this would apply. But the commission has also said that even acting as a spokesperson for kind of a neighborhood group, there's some new project going in and everyone on these few streets is concerned about it. You get together with them and talk about it. When they come before the Board of Selectmen, if you have a town office, don't be the one who stands up and is a spokesman for the concerned citizens of Main Street. Let somebody else do it. You can help behind the scenes if you're use your knowledge for that, but don't act as the agent, because it is again one of these things which is the Ethics Commission interprets very broadly. It is only triggered if you represent someone else. You're always entitled to represent yourself. So if you have a town office and you get your tax bill and you want to apply for an abatement, filing it with the assessors, coming in before the Board of Assessors and meeting with them, that's not acting as an agent for someone else because you're representing yourself. A little different result if the property you want to apply for is owned by a trust, because then it's not really you, but just something to be aware of. You might need to get somebody else to come, be your agent. Let's see. Yes, behind the scenes is okay. So this is one of the regulations the Ethics Commission adopted to try and make things not quite so onerous on people. I think there's a word missing on here, but sometimes people may be interested in a particular area, and so they serve on the town board. One kind of classic example is library. Somebody really wants to help the public library, so they serve as a library trustee. And then there's a private nonprofit, the Friends of the Public Library, very frequently found in cities and towns. And they do various things. They fundraise, and they will inevitably have some interaction with the library trustees. Well, if you're on both of those things, then there's those two hats again. Again, no bad intent, but that's something which Section 17 is going to have an issue with. This regulation they adopted, the Ethics Commission acknowledged that this was out there, that this really wasn't the kind of serious conflict that this section is after. So they said that if a board wants to authorize a member of that board to serve as its representative on a nonprofit board, then that won't violate Section 17, even if there's a little sort of communication back and forth, the same person may be signing off in both capacities. So that's at least a limited way of trying to avoid that. But if, it's not just libraries, if you're aware of other situations where you might be part of a group that interacts with the town, you'll have to just have to be aware of that issue and see if any of the exemptions might apply. You can't always advocate for yourself. Section 19, that's one of the two that comes up most often. And Section 19 says that a municipal employee, and special employees get no separate treatment here, may not participate in your official capacity in any particular matter in which you, your immediate family, or your private business or employer has a financial interest. And one thing the Ethics Commission says about this is a financial interest is a financial interest. We don't care how big it is. We don't care if it's positive or negative. They had one example from, it's quite a while ago now, but where they found that a member of a board of health, I believe, sat in on something to do with a landfill which was going to be put in across the street from property that he owned. And the Ethics Commission said, that violates Section 19. You have a financial interest in that. That might impact your property value. And he said, but I know it's the right place for this, and if anything, it's going to hurt my property value. So how could this, violate Section 19? Well, that's when the Ethics Commission said, it doesn't matter if it's positive or negative. if it affects your financial interest, or if it's reasonably foreseeable that it might affect your financial interest, that triggers Section 19. So, you know, again, this comes up all the time. There are, the commission has some general advisories that say if you're in your official capacity, something's going to come before you that that involves property which directly abuts yours, or you're an abutter to an abutter within 300 feet under the Zoning Act, that the Ethics Commission says, we're just going to deem that you have a financial interest in that because it's close enough that it's at least foreseeable that it could affect your financial interest depending on what happens on the piece of property that's in front of you. And so, in general, there's two things that you can do. If you're an elected official and you find yourself in that situation, you basically have to step away because there's no exemption in Section 19 for elected officials. So if you're a member of a multi-member board, hopefully you can still get a quorum with you sitting out because you're going to have to do so. If you're an appointed official or you're on an appointed board, you can fill out a written disclosure of the facts, file it with your appointing authority, and whether that's an individual, you know, the town administrator, or whether it's a board of selectmen. If your appointing authority will approve your exemption and sign off on it, then you can participate even though you have this financial interest. The theory being that this is all done sort of publicly, it's a public record. What the appointing authority is supposed to conclude is that they look at the financial interest and they don't think it's significant enough to affect the integrity of how you're going to handle yourself. And if they do that, and if it's a small financial interest, it's perfectly reasonable to make that conclusion, then you can do that and allow the person to participate. The other, let's see, profit. Okay, Section 20 is another one which comes up a lot. It's an extremely long section and it's really painful to read through. And it turns, more than any other, it really turns on specific facts. Basically what it says, if you're a municipal employee, you cannot have a financial interest in a contract with the town unless you qualify for one of the exemptions. And that could include a contract that your private employer gets with the town. If you yourself have a financial interest in that contract, that would trigger Section 20. It also applies if you hold one town office and then you want to acquire a second one, which is paid. That's also considered a contract. The Ethics Commission has said that elected offices that are paid, they don't consider that a contract because there's really no way to kind of get an elected office through favoritism. You have to get elected by the voters. So they say those are not contracts. There are a lot of different exemptions. Special municipal employees, again, it's a little bit easier. You can acquire this interest in the contract just by filing a written disclosure, or if it's in your same department or office, you might need to get the Board of Selectmen to also approve your exemption. There's a special exemption for part-time or call firefighters or public safety officers to make it a little easier for someone, to encourage people who want to do that. It does require the selectmen to approve it, but again, it's not barred. Certain housing, subsidy programs and that kind of thing, which technically are contracts, again, as long as there's a disclosure is made, those are also okay. If you don't qualify for some of those, then you're left with this 20B exemption, which is the regular or non-special employee exemption, and it has about 9 different sections to it, and it's pretty hard to fall under it, but it is there and it works sometimes. First of all, the contract. So you have one position and you want to get a contract. again, with your outside employer or a second position with the town. It has to be in a different department. You can't get 2 jobs in the same department. The contract must be awarded after public notice, and the Ethics Commission has said they think that, at a minimum, that means published in a local newspaper, not just tacked up on a bulletin board in town hall. They do say with a newspaper, I think if it's the kind of contract that requires bidding, you know, an RFP goes out or something, I'm sure they would say that would be fine as well, because obviously that's as public as a newspaper. If you get the contract, you have to file a written disclosure with the town clerk of your financial interest in this new contract. And if it's for personal services as opposed to selling some kind of product, then there's several other things you have to meet. The second town position has to be outside the normal hours of your primary position, so you're not doing any double billing. You have your one position, and the contract you want to get is for no more than 500 hours a year, so that's only, I think it's a little less than 10 hours a week. The head of the contracting agency files a certification with the town clerk, I believe, that says no one in this department is available to fulfill these duties. So it's kind of there to prevent someone from you know, creating this kind of phantom position for their best friend or something along those lines. And after all that, the Board of Selectmen has to vote to approve your exemption, which is a discretionary decision for them. So, as you can see, it's not always easy. I will say that one of the regulations which was adopted, the Ethics Commission adopted a few years back, was to address a problem which we dealt with all the time, and I always hated giving this opinion, where you had someone who had a paid town position. You're having trouble filling positions on the ZBA, so they say, you know what, I can do that. You know, I'll volunteer to serve on the ZBA. And so when they get appointed to the ZBA is unpaid, so there's no contract issue there. But as soon as they assume that office, they now need to look back because they need an exemption under Section 20 to have their main paid position that they had in the first place. And so sometimes they couldn't meet these detailed qualifications, and we'd have to say, you know, sorry, you can't do it. It's illegal for you to volunteer to serve on the zoning board. Didn't make a lot of sense. And so the Ethics Commission finally kind of met halfway on that, and they adopted this regulation which says if you have a paid position first, you can accept an uncompensated position and not have to worry about Section 20. In other words, you don't have to look back and qualify for an exemption as a ZBA member. So that was very useful when they approved that one. Some of the others, I do address some of them in this letter, but oh, that's the one I just mentioned. Uncompensated, by the way, is a position which offers no compensation. That might seem obvious, but previously the Ethics Commission had said if you want to take on a second position that's paid, that triggers Section 20. But if you refuse the compensation, you might be able to avoid Section 20. That's no longer the case. They say uncompensated means there's nothing offered. You can't just decline to accept it and get around the prohibition. Okay, and then the next one, which comes up again all the time, Section 23, referred to as the Code of Conduct. It kind of deals with everything that wasn't hit by the first sections. And two in particular come up a lot. Section 23B2 says you may not use or attempt to use your public office to obtain for yourself or anyone else any unwarranted privilege of substantial value, which again is $50, which is not properly available to similarly situated individuals. So for the most part, this is, it's fairly obvious. You know, don't use your public office to try and you know, pressure somebody, you know, to gain something something of value. That's obviously not why you're in public office, and the Ethics Commission does does keep a close eye on any sort of, behavior that might trigger that. There is no disclosure for this one, because it's really, this is an intentional violation, if you will. You're using your office to try to get something which people who aren't in your office wouldn't have the same opportunity. The other one is section 23B3, and this one we call the appearance section, because it says don't act in your official capacity in any manner which would cause a reasonable person who has knowledge of all the relevant facts and circumstances to conclude that you are acting with bias or favoritism or for personal reasons as opposed to the good of the town. And so whereas B2 was don't do something which you're using your office improperly, this one's don't do something which someone else might appear to them that you're acting with bias or favoritism. So that obviously is kind of harder to keep track of sometimes, but there is the second sentence in this section says that it shall be unreasonable for someone to make that conclusion if before you take the action you make a written disclosure of the facts and you file it either with your appointing authority or with the town clerk if you're elected. And so this one comes up all the time, and I'm always very conservative in my advice. We get questions about, someone will say, well, there's something coming up before my board tomorrow night. It's an application, and it's not my immediate family, it's not my employer or anything like that, but it's from a guy who everyone in town knows has been my best friend for 30 years. We take vacations together, and I'm concerned that people are going to think that I'm going to act, with favoritism on his. I'm not going to. I'm going to look at the application like I do all the other ones, but I'm concerned that it's going to look bad. And so, I invariably will say, well, if you're even having that thought, why not just fill out one of these disclosures? Nobody has to approve it. You just have to put it in writing and file it, and then you're all set. So then if somebody complains after the fact, hey, I think you violated section 23 when you acted on your best friend's application, if you filed that disclosure, you're good to go. If the Ethics Commission gets that complaint, they will say, well, was a written disclosure filed? And if it was, that ends the discussion. So, remember that one. It does come up all the time. It does, it has to be a reasonable appearance, but that's a pretty low bar. So it's always better to file the disclosure if you have any concern about it at all. My slides don't really talk about it, but the Ethics Commission, in addition, oh, sorry, yeah.
I have a question about filing disclosure. If you're on a board, using that example, you're acting on a permit application and it's your best friend. When you file disclosure, do you state that at the meeting? Does that become public? I mean, when someone recuses themselves, they say, I recuse myself, I've had business dealings with this person and I leave the room. Where does the disclosure go?
The statute itself does not require that kind of, it does not require you to also say it at the meeting. What's required is that it be put in writing and then filed either with the appointing authority or with the town clerk. So then it becomes sort of a permanent record. Sometimes the facts may be, the appearance is so close and so obvious that it might look bad. That I might also say, and if you're really concerned, if you think that there's going to be 20 people in the audience who are concerned, think that you're going to be acting with favoritism, it couldn't hurt to also say, just for the record, I have, I talked to town council and I have filed a written disclosure about my relationship with this applicant. You can do that, but to meet the requirements of the statute, the written requirement is all that's necessary. But it does need to be filed before that meeting, not afterwards. Yeah.
Could you just repeat that just for the folks at home?
Sure. The question was under this section 23B3. Is it also required to make an announcement if you're a board member? Make an announcement at the meeting to say the same thing. And the statute does not specifically require that. you might, if you feel better doing so, just to alleviate this potential appearance, you can. But the statute itself only requires the written statement to be filed with the appropriate office before that meeting or before you act on whatever's hitting your desk. I was going to say that in addition to the legal division, which gives their own opinions and also reviews opinions that are filed by town council on these conflict questions, there's also an enforcement division. And if somebody, anybody, the town official, any member of the public, reporters, and all kinds of people file complaints. But anyone can call up or write the enforcement division of the at this commission and say, I think so and so, this the town official violated one or more sections of the conflict law. Here's what happened. The enforcement division will look into those, and they may call, if it concerns you, they may call you and say, we've received this complaint. They may ask for copies of some correspondence or something which might shed light on it. They will not tell you who filed the complaint. It's all handled confidentially. And then depending on what they conclude, if they decide there wasn't any violation at all, they'll probably send you a letter saying, we looked into this, we don't think there was any violation. They might send you a letter, and they send out lots of these every year. We received a complaint, that alleged A, B, and C. If these facts were true, you may have violated Section 19 because here's how Section 19 works. Now that we've advised you of how this works, we're going to consider this closed and not do anything further. So with those first two things covers, most of the complaints. If they do decide that it was a serious matter, they think maybe a contract, was awarded improperly or kind of behind the scenes, they can open kind of a official administrative hearing. The Ethics Commission members themselves sit as judges on that. And they do act on several of those a year, but for the most part, the complaints get resolved more informally. Just a couple of things I'll hit. We're getting near the end. The Ethics Commission issued a couple of advisories in the past year or two because they said they were getting lots of questions about the conflict implications of these matters, and so they decided they'd sit down and approve formal writing. And one of them concerned fundraising or making solicitations on behalf of the town. Is this a conflict? And so they said, in general, it's not. Again, I'll use the library as an example again. Can the library employees put a bin out on the counter and ask people to please support the this year's book drive? The Ethics Commission said that in general that would be okay. Any funds that are donated need to be handled under Chapter 44, Section 53A, which says that any gift which comes into a town has to be put in a special account. The treasurer keeps it all separately. Before it can only be used for the purpose of the donation, and before it can be spent, the department that the gift was given to has to get the Board of Selectmen to sign off on the funds being spent. Again, just to kind of keep it all above board. And no overt pressure to make that kind of gift can be used. If town employees are doing the soliciting, they should try to be objective on who they're dealing with and not deal with someone who might feel uncomfortable or pressured. And also, the employee doing the soliciting is supposed to keep track of the names and a written track of the names and file it with the town clerk of people they may have solicited. So there are some hoops to jump through there. But in a lot of cases, this fundraising will not pose a problem. The regulation does use the term, it can't be inherently coercive. And I'll give just another hypothetical. Let's say you're dealing with a commercial business that has to get a fire inspection every year. and the firefighter shows up at the door soliciting for, raising money to buy some new, air packs or whatever it might be. And so you show up encouraging them to make a donation and say, by the way, I think you're up for inspection in a couple of weeks, aren't you? Though that's kind of the inherently coercive issue. If the town official who's doing the soliciting is in kind of a permitting or approval situation, might want to refrain from soliciting people who you have that official interaction with. This is another one which I didn't realize had come up that much, but the Ethics Commission thought it was worth a special thing. And that's when, if you're a town official or employee, particularly if you're a department head, and you're asked to give an employment recommendation. Can you do that in your official capacity because you may be, giving a favor to someone? And they said, well, it's permitted if you're using your official letterhead and you're giving a recommendation for a former town employee, because then it's kind of in the normal course of you're the kind of person who the prospective new employer will want to hear from because you're the former boss of this man or woman. And so an official kind of recommendation on town letterhead is fine for that. However, using your office and town letterhead for someone else is not okay. Using your letterhead to give a recommendation for your nephew who's never done anything for the town, Ethics Commission says that's improper. That's improperly using your office, and that would be a violation of 23B2, as I mentioned a few minutes ago. And also, aside from the letterhead, don't kind of try to throw your weight around with your town office in trying to influence someone else to hire somebody, which could even apply within another town department, I suppose. All right. Well, that sort of brings me to the end. I did mention the legal division and the enforcement division of the State Ethics Commission. And they also have a website which I think is pretty good. There's a lot of information on there. Two tabs I would specifically mention if you think you have an issue that might be problematic and you want to find out. You can call them up, ask for the attorney of the day. You can ask for a formal opinion from my office. If I write one of those, I send it to you because you asked for it. I copy the town clerk's office. I also copy the Ethics Commission, and then within 30 days, usually within a week or two, the legal division writes back and says, Mr. Riley, we read your opinion and we agree with it, or we would also add the following caution. But their website also, in particular, if you click on educational materials, there's lots of advisories. They have kind of summaries for all these different town offices. Because the law works a little differently for them. And there's also a long list of disclosure forms. So you can find the right one you need for the right section and print it off, and it makes it a little handier to file them. And other than that, unless you have any questions, that's my presentation on the mighty conflict of interest law. All right, so thank you very much for your attention.
Are there any questions?
Actually, if you don't mind, could you use the mic just so we try to help people at home?
Craig Wiegand, Water Superintendent. What about gifts between staff? Is it, I understand it's a $50 value, but say one person's dating another person in a different department or something like that and gives that woman an engagement ring. What is it?
Well, I think the argument I would make to the Ethics Commission is that gift, regardless of what the value is, was not given for or because of any official act. You know what I mean? The one person is giving to the other one for purely personal reasons and not because of something they did in their official capacity. That's really kind of the dividing line. Like they say, it's you want to give a person in your department a birthday gift, you can do that. You can give them $100 gift, because you're not giving it to them because of something they did in their town office. You're giving it to them because, it's your friend and it's their birthday.
Okay,
So
good.
that's the way that
And
exemption
that would be the
works.
same thing, like if you wanted to give your department a recognition type thing or something like that, where you want to just hold a lunch or a dinner or something and say, I pay for it with my own money. I understand, as long as it's not paid for with town money, then would
Yeah.
that be acceptable?
When it is, sometimes these kind of parties are held with town money, and DOR weighs in on whether they approve that or not. It would, in that case, I think you'd
Should
have
you
to be
do a
careful.
disclosure?
Yeah, I think you'd have to be careful, just because it's possible someone would conclude that, if they've reached their 20-year anniversary. Again, I guess I would try to argue that this is a little closer with that, so you might want to talk to the legal division about that. I think I would argue that, where this gift is in recognition of so-and-so, working in the department for 20 years. It's not tied to any particular thing they did.
And it's not town money.
And it's now town money, right? So I think you could still make that fit, but it's a little bit closer than the first example about an engagement ring or a birthday present.
I do have just a couple maybe. Just every once in a while during the holiday season, companies will do like a fruit basket or something like that. And like, I know what I've done is I've made it available to staff as opposed to just me taking it home. Is that a permissible practice?
Yeah, that's how you avoid the problem. If somebody comes in and says, here's this fruit basket, it's worth $100, just want to say thanks. Yeah, if you kind of make it available, then it's more like it's a gift to the town. The conflict law is always geared towards, individual. You as an individual can or can't do something. So if you treat it more as a gift to the town, it's available to everyone in your office or everyone in town hall, then you would avoid that kind of problem.
Because I did have a circumstance once in which one of my staff did something for a resident. The resident gave him a gift card for $50, and we encouraged the staffer to return the gift card because it was just part of his normal duties, and he did.
Yeah.
But those circumstances do happen. And then second, I've had the unfortunate time in my career in which I had a person that went in, they filed a disclosure, and had an ethics opinion, and then did everything opposite what the opinion said. And could you speak to a little bit the importance of, if you're going to get an opinion, you need to adhere to the elements of it?
Well, yeah, you do. We talked about the sections where, if you do something, it's going to violate this section or that, but you can file a disclosure, and it may or may not need to be approved. But then, yeah, you have to follow through with what you've disclosed, and yeah, if you get an opinion, whether it's from me or the Ethics Commission, you say, here are the facts, A, B, C, D, and E. Am I okay to go ahead and act on this? And if they say yes, but then you left out two important facts, F and G, the Ethics Commission would certainly say, well, we're not bound by what we told you the first time because you didn't tell us about that one. So yeah, you really do need to, full disclosure is very important, and following through on what you put forth as the facts. Absolutely.
Thank you. And I asked a couple just to kind of get things started. Does anyone else have anything, or I'm just trying to think of a few incidents that I've had in my experience? If not, then we appreciate you coming out, and appreciate it being filmed. And thank you, Brian, for your presentation. Very good.
All right, my pleasure.